Well, hello everyone, and welcome to today's FedSoc Forum. Today, June 18th, 2024, we are excited to present Cryptocurrency and the Bankman-Fried Litigation, Lessons Learned. My name is Jack Capizzi, and I'm an Associate Director of Practice Groups at the Federalist Society. As always, please note that all expressions of opinion are those of the speakers on today's call. After our speakers have given their remarks, we will turn to you, the audience, for whatever questions you might have. If you have a question at any point during the presentation, please just type it into the Q&A function at the bottom of your screen, and we will handle those as we can towards the end of the program. With that, I'll turn it over to our moderator today. Today's moderator is Christian Johnson, who is a Commonwealth Professor of Law and Business Advising at Widener University Commonwealth Law School. Christian, over to you.
Terrific. Thank you very much. We're really excited to be here. The Sam Bankman-Fried trial, in my opinion anyway, was one of the most important cases and litigation that happened in 2023. And it had all of the drama. It dealt with cryptocurrency, actions in foreign jurisdictions, great personalities involved with this. And it really is extremely interesting how it played out and what happened and what's going on. We have really a unique opportunity today. We have Nick Roos, who's the Assistant U.S. Attorney at the U.S. Attorney's Office for the Southern District of New York. Mr. Roos joined the U.S. Attorney's Office in 2016 and has been a member of the Securities Commodities Fraud Task Force and the Public Corruption Unit. Now, Mr. Roos was one of the lead prosecutors in United States versus Samuel Bankman-Fried and in other criminal cases relating to the collapse of FTX. He previously also worked on criminal prosecutions relating to insider trading in cryptocurrencies and digital tokens, including U.S. versus Chastain and U.S. versus Wahi. Mr. Roos is a graduate of the University of Vermont, University of Chicago, and Stanford Law School. We also have Mark Cohen, who was the lawyer for Samuel Bankman-Fried in this case. Mark is the co-founder of Cohen and Gresser's New York office and head of the firm's litigation and arbitration and the white-collar defense and regulation groups. Mark's litigation practice focuses on complex commercial litigation. He also represents companies, corporate boards, board committees, and individual clients in white-collar criminal cases, federal and state regulatory proceedings, and corporate internal investigations. Mark is a fellow of the American College of Trial Lawyers. He maintains an active trial practice of both civil and criminal cases and has tried approximately 25 cases to verdict. Prior to co-founding Cohen and Gresser, Mark served as an assistant United States attorney for the Eastern District of New York and formerly practiced with Fried-Frank. He's a magna cum laude graduate of the University of Michigan Law School, where he was a note editor of the Law Review. Now, just to give you a little bit of background on the case, I'm going to go ahead and share my screen here. Terrific. Gary, do I have a good share there?
Excellent.
Okay, good. Our two panelists again that I've just introduced. The case, of course, focuses on Samuel Bankman-Fried, U.S. versus Samuel Bankman-Fried, shown here with a photo of Mr. Bankman-Fried. The accusations against him, and this comes from the U.S. Department of Justice, accused of misappropriating billions of dollars of customer funds deposited with FTX, defrauded investors in FTX of more than $1.7 billion, defrauded lenders to Alameda, which was a trading company of FTX, of more than $1.3 billion. Now, in addition to, just to give a little background on FTX, FTX was the cryptocurrency exchange, and another company owned by Mr. Bankman, of course, was Alameda Research, which was the trading company. FTX was founded in 2019 by Mr. Bankman and Gary Wang. In July of 2021, to show kind of the scope and how large the exchange was, it had 1 million users, $1 billion in revenue, and $272 million in operating income. It was the third largest cryptocurrency exchange and is currently in Chapter 11 bankruptcy. They had a 1-month trial that concluded in November of 2023. And as I'm sure our panelists will talk about, the trial was quite speedy, I guess, is one way to put it. He was found guilty on 2 counts of conspiracy to commit wire fraud, 1 count of conspiracy to commit securities fraud, 1 count of conspiracy to commit commodities fraud, and 1 count of conspiracy to commit money laundering. In March of 2024, he was sentenced to 25 years in prison, 3 years of supervised release, and ordered to pay $11 billion in forfeiture for multiple fraudulent schemes. Again, this is coming from Justice. A quick update. Upon conviction, Mr. Bankman was initially sent to the transfer facility in Oklahoma, but he's been brought back to the Brooklyn MDC, which I believe stands for the Metro Detention Center in Brooklyn. Currently, Mr. Bankman's preparing an appeal of his conviction and sentencing. He's filed a notice of appeal, but we don't have any filings yet as to the basis of his appeal. It turns out he'll probably request to serve his prison sentence in the San Francisco Bay Area, where his equally famous Stanford Law School parents reside in that area. One thing that was interesting, in addition to the conviction of Mr. Bankman, was the bankruptcy of FTX, the cryptocurrency exchange. The company filed for bankruptcy in November 11th and 14th, which sort of started the cascade of what was going on in 2022. To show the complexity, in addition to FTX, over 100 other related entities also filed for Chapter 11 bankruptcy at the same time period. The bankruptcy court's full course was to recover a lot of the customer funds that were held at the exchange. In an interesting, really interesting kind of turn or twist in this particular case, it appears that the claimants may recover up to 100% of their claims. Now, those are claims, though, that were based on the valuations in November of 2022. So, of course, there's been a lot of appreciation, but it's an interesting twist in that the actual claimants may recover a lot of their losses in this particular case. It was interesting because FTX owned and Bankman owned a lot of digital currencies, which ended up appreciating. They also owned shares in startup companies, which have also appreciated as the cryptocurrencies have gone up and down. Even though we've had these recoveries, the court rejected the arguments, though, that just because these assets have appreciated, it should not make any difference in the sentencing that was going on. Another kind of interesting fact about it is that it's estimated that the fees involving the bankruptcy of FTX are probably right now over $320 million. And probably going to be great, which is just part of what happens when you have these enormously complex and difficult cases that go on. Let me end this share here. Well, terrific. That was a little bit of background. Please, Mark and Nick, correct me if I got some of those facts wrong. What we're going to do is we're first going to turn some time over to Nick Roos, again from the U.S. Attorney's Office and one of the prosecutors in the Bankman criminal trial, and he'll discuss some of the positions and thoughts he has in acting as the prosecutor in this particular case. We'll then turn time over to Mark Cohen, and he'll talk about his role and his observations and views on what went on during the trial. After we've heard from our two panelists, I've got some questions, and we'd be happy, of course, to take questions from the audience as we sort of explore this very unique and an important case that happened. So, Nick, we'll turn the time over to you.
Thank you. And let me start by thanking Christian and Gary and Jack, who's off screen now, for organizing this discussion, and to the Federalist Society for hosting. It's great that you folks are able to facilitate these things, and it's always a pleasure to do something else with Mark. This is our, I guess, second of perhaps many of these events to come. So let me just start, and Christian already previewed it, with the caveat that, my statements today don't reflect the official views of the Department of Justice. I'm constrained in that I can only speak about information that's publicly available in our court filings and stated in court, nothing that's confidential or internal. Also, there are some related matters around Sam Bankman-Fried, not his case directly, but some of the other individuals that still remain pending, and so I can't comment on those. All those caveats aside, I thought maybe it makes sense just to give a little bit of background, building on what Christian started with on the case and the genesis, and kind of how we got to a point where we were doing a trial about a year after the company collapsed. So basically, for those who aren't familiar with it, FTX was one of the largest, but not the largest, cryptocurrency exchanges. There was what some people have called a run on the bank, and it's was termed, some folks termed it as a liquidity crisis, other people framed it as a solvency issue. But in any event, there was issues with the exchange about 1 year prior to the trial that resulted in its declaration of bankruptcy, and ultimately, not that long after, public investigations by the Department of Justice through the U.S. Attorney's Office here at the Southern District of New York, as well as by the SEC and the CFTC and maybe some other regulators. And not that long after it, there were criminal charges about around a month after, maybe a little more. And those charges were brought against Sam Bankman-Fried and a few of the other executives, both at FTX and at Alameda, which is, as Christian said, the trading firm that Mr. Bankman-Fried also operated. And I think I'll just stop there for a second and note that the speed with which the prosecution was brought is something that's been highlighted, not necessarily by me, but by the U.S. Attorney here, Damian Williams, the importance of that, both for preserving assets, compensating victims, achieving justice, and sending a strong deterrent message. That's something I think he emphasized at the time of the charges, and through the time of the trial and even sentencing. And so I think that's sort of one of the defining elements of this case, is just the speed with which charges were brought, and then the speed with which the trial happened, and in some ways I think maybe it's a counterpoint to some other investigations that have dragged on for a long time. I'll say I think there's a public sentiment sometimes that government investigations carry on for years, and that victims are left in a bad spot, and justice is delayed. And so I think that was an important feature of this case, was that the justice system, while not in total lockstep with events unraveling at least was not so far behind. So it gave people a sense that justice was being achieved, on a pace similar with as events were unraveling and as the bankruptcy was happening. So let me take us back then to the sort of the chronology of the case. The case is charged. Mr. Bankman-Fried was in the Bahamas. He was arrested there on a United States warrant executed by the authorities in the Bahamas, and then entered into an extradition proceeding. He was detained there and then extradited. He waived the lengthy extradition process, which resulted in a faster return to the United States. In some other criminal cases, these extradition proceedings go on for years. And so we'll have cases where a defendant may be somewhere in Europe for, between 1 to even 5 years, which results in obviously a slower pace to the case. Mr. Bankman-Fried returned to the United States, and we had, pretrial litigation that I would say was largely kind of what you would expect of a big case. There was motion practice. Mark and his team made some interesting motions that we could talk about more, but in any event, we headed to trial. We started the trial. It was about a month or so long. It featured, I think, one thing that was sort of interesting about this case is it featured 3 former insiders who were cooperating witnesses. Those were sort of central pillars of the government's case, and as well as a bunch of other evidence you might expect. We had an expert witness who did some of the financial tracing work for us, and some other fact witnesses, victims, and then of course a lot of documents. And
Nick, have the 3 insiders also been sentenced already? Are they?
Good question. They have not.
Have they been convicted or pled guilty?
So the way it works is that at least in the Southern District of New York, when cooperators agree to cooperate with the government, they have to plead guilty to all of their crimes. So they enter a plea agreement then that we sometimes call a cooperation agreement. And then they're typically sentenced at the conclusion of their cooperation. So it usually happens after any trial of defendants who are not cooperating. I'll say this is kind of inside baseball, but some other districts within the Department of Justice do a little differently. I think the practice in California, for instance, is a little different. But here in the Southern District of New York, the way it works is they have to plead guilty to all of their conduct. So they don't get sort of a break on not having to plead to something. You have to plead guilty to everything under the cooperation agreement. And then they're sentenced later on at the conclusion of sort of the whole case. So so we had the trial. Went about a month. Mr. Bankman-Fried was convicted, and then typically what happens in a criminal case is the judge sets a sentencing date that is rarely sooner than about 3 to 4 months. They usually put the case out at least 3 to 4 months to provide time for the probation department to prepare a report that's called a pre-sentence investigation report, and to allow the parties times to put together sentencing submissions about what they think the appropriate sentence would be in the case. And then a sentencing's held, and in this case, that happened earlier this year, and Judge Kaplan imposed a 25-year sentence, as well as some other financial components. And that was really the case.
Terrific. Eddie, your thoughts on when justice went into this and the prosecutions? One issue is cryptocurrencies are complicated and difficult to understand. How did that influence your approach, and were you able to simplify things for the jury? Kind of how did you approach that?
Yeah, it's a great question. There's the case, the subject matter is, of course, about cryptocurrency to some degree, but the criminal charges are not. There's no cryptocurrency crime. The crime is alleged as wire fraud and securities fraud, so various forms of fraud. And here, the theory was that he misappropriated money that had been entrusted to the exchange, had made false statements to customers and to investors and to lenders. And so when you think about it from that lens, there's nothing really about all of this at that very high level that is about cryptocurrency. You could imagine, and in fact, there are cases historically about someone who runs a bank who embezzles money and makes false statements to investors, and they're prosecuted and go to jail. There are cases about good old-fashioned lenders who lie or are the victims of lying and lend money that they wouldn't otherwise lend. And so I think, thinking about this as a case of old-fashioned fraud, but in sort of a modern day age is sort of I think a useful framework for thinking about how much cryptocurrency now really needs to go into this. Now, there were some aspects of the case that I do think were sort of cryptocurrency specific. So one is the financial tracing. And there was an expert, a professor of accounting from Notre Dame, and he testified about the tracing of money and the balances that existed. And that work required, calculating the amount of available cryptocurrency and tracing cryptocurrency, as well as some conventional, stable coins and also fiat currency, so like dollars, et cetera. But that accounting work is really in some ways no different than what you would do if the case involved dollars and pesos instead of dollars and cryptocurrency. So, but certainly the financial work in the case to prove the movement of the money required, discussion and some expertise around cryptocurrency. And then another sort of crypto-specific aspect of the case just had to do with how the exchange functioned. So you can make at a very high level the argument that he stole money, but then of course, as witnesses testify, as the defense makes arguments about how things were authorized or there was ambiguity, that requires more nuance and understanding about how the FTX exchange worked and how cryptocurrency exchanges work generally. And so I think that was another area where cryptocurrency really came to play in the case, was getting an understanding of these exchanges. Now, you mentioned, Christian, at the beginning that I'd worked on a few other cryptocurrency cases, but I think really for like any prosecution or defense attorney, in many of these cases, we've got to learn the subject matter, the specific facts of the case. And so I think that, with this one, that was learning about FTX and learning a little bit more about cryptocurrency generally.
Terrific. That was a great introduction to what happened. Mark, why don't we turn the time over to you now and to talk a little bit about on the defense side and your observations and approach and how you dealt with the case.
Sure, and again, like Nick, I'd like to thank the Federalist Society for inviting us. It's a pleasure to be here. Thank you to Gary and the team, and thank you, Christian, for having us. And like Nick, I have some caveats that I should say at the beginning. I no longer represent Sam. I'm not handling the appeal. Sam, as everyone knows, has maintained his innocence. He has a constitutional right to trial, which he exercised, and now he's pursuing his constitutional right to appeal. So I'm not going to comment on that. I'm also not going to comment on anything that was confidential between he and I as lawyer and client, or as defined under the New York Rules of Professional Conduct 1.6. So with that caveat, and I should also say it is always fun to be with Nick again. So good afternoon. Now that we're out of the sort of day-to-day serve and volley of the trial, which I think Nick would agree was an incredibly intense experience for not just the client, but the attorneys, the court, and the observers. I've tried to look at this and think about this from sort of what are the lessons, what are the takeaways, and there are many, but I think for today's purposes, I'd just like to talk about three of them. One is sort of the reverse of Nick's point about speed. Now, I've been doing this kind of work for more than 30 years. So, every prosecutor you ever speak with, whether they're brand new or they're the U.S. attorney, will tell you that they want to move things quickly. And I understand that. I was a prosecutor myself once upon a time. But it did seem in this investigation and the one of Binance, which was the number one crypto exchange in the world, FTX was number 3, that speed was elevated, as Nick pointed out in the comments by the United States Attorney, to a level that we rarely have seen in the Southern District of New York, almost above other considerations. And now that we're out of the Sturm and Drang of the day-to-day of the trial, I think there's some interesting lessons about moving at that pace. One of it is, we certainly in my view, we wound up with a regime where we were regulating a new product, crypto, or new asset class, digital assets, by means of enforcement proceedings and criminal prosecution, rather than a more traditional approach. Crypto, as Nick pointed out, sort of began to become known in the mid-2000s. It is like other asset classes, but it's also very much unlike that. It's not backed by a government. It had little regulation internationally. Trades take place on this something called the blockchain, which is this giant digital ledger. There were at one point something like 12,000 different cryptocurrencies that you could buy or sell. It wasn't just Bitcoin, which most people know about. And there were no intermediaries. There were no banks or brokerage firms. In fact, the whole idea of FTX as an exchange, or Binance as an exchange that might be intermediate between buyers and sellers of crypto, was considered radical by some of the purists on crypto. And so around 2021, 22, when these events started to happen, there were still many unanswered questions about how this all worked. Were cryptocurrencies securities? That question actually still not answered by the courts. There's court opinions across the country going in different ways. Were they commodities? It's also still not answered. The CFTC has taken the view that Bitcoin is a commodity, but as to the other 11,999, we don't know. How should the market be regulated? Should it be a regime that's risk-based, disclosure-based? Should the SEC be in charge? Should the CFTC, some other entity? There was just an act passed by Congress last month, so 2 years after this investigation began, called the Financial Innovation Technology for the 21st Century Act, which divided up regulation between the SEC and CFTC over the objection of the chairman of the SEC. So very much in flux. And, think about capitalism as it generates.
I think that was just passed by the House, right? Has the Senate?
Yeah, that's right. But the point is, it's still undecided. That's really my point. And capitalism creates new markets, new products, new territories all the time. It's done it for hundreds of years. And over time, there are different ways for government and government regulators to respond. Other times we've seen what at least I would call a more staged approach, where there's first rulemaking, examination, maybe civil enforcement, and then only then, if those things do not sort of bring the market into order, criminal prosecutions. And here we sort of had the reverse of that, where we had two criminal prosecutions that were brought right around the time, as Nick pointed out, that the crypto market crashed. Now, just give everyone sort of context. Imagine that at the time of the world financial crisis in 2008, instead of having the government recovery programs and the wave of regulation that came about, we had just gone right to criminal prosecutions. And I think it led to, at least certainly from a defense point of view, some outcomes that are hard to square and seem to me anyway to be, at least in part, a product of moving so quickly, not going through the stage process that the government has used. For example, 5-6 years ago, cybersecurity was the rage, and the SEC had a program of examination, rulemaking, so on and so forth. So we had an outcome in which, as Nick pointed out, FTX filed for bankruptcy, went out of business as the third largest exchange in the world, even though all of its customers are now going to be paid back 118%. Sam exercised his constitutional right to go to trial. He consented to extradition, and he was convicted and sentenced to 25 years in prison. Whereas Binance, where the case happened to be brought in a different district out in Washington State, paid $4.3 billion in fines, pleaded guilty to conspiracy to conduct an unlicensed money transmitting business and violating sanctions law, and was permitted to stay in business, even though it admitted in its criminal proceeding and related civil proceedings that it had been funding sanctions countries like Iran and had been funding U.S. designated terrorist organizations. But they wind up staying in business, and the CEO of Binance, CZ, so he's known by in the crypto world, he gets sentenced to 4 months in prison. And I think it's really hard to square those outcomes. You could say, well, different districts, okay, different, CZ was based in Dubai, different extradition analysis, maybe. One exercised his constitutional right to trial, one did not. But it seems to me it's still hard to square from a policy point of view and a society point of view. And at least my view is had things moved in a more slower pace, a more traditional pace, even if there had been these prosecutions years later, the outcomes would have been closer to each other, wherever they had wound up. And I think what we're left with from a policy point of view is it's still unclear to the market what the rules are and what participants are supposed to do. Coinbase, which is one of the leading exchanges in addition to FTX and Binance, has shifted to an international expansion. And one of the stated reasons they gave for it was they would like to remain active in the United States, but this is their words, not mine, but a regulation by enforcement approach in the U.S. is leading to a disappointing trend for crypto development in the U.S. They brought a lawsuit in the Third Circuit where they sought to get the SEC to issue rules about the do's and don'ts in cryptos because the SEC refused to. And what's interesting to me, sort of from a stepping back point of view, is 5 different amicus briefs were filed in the case, including one by the U.S. Chamber of Commerce, which is hardly a radical crypto organization. It's the traditional U.S. business organization. And so we've had these trials, they've had their effect, and they certainly got plenty of attention. Nick and I can tell you every day, we were sort of mobbed by the media coming in and out. But the market, at least in my view, is no wiser than it was 2.5 years ago. Another thing, and I think in part that's a function of the speed with which things were done. Another impact, I think, that the speed had was on extradition. And as Nick mentioned, Sam consented to extradition. And without getting into the technicalities of it, there's a rule, extradition is governed by treaty between countries, and there's a rule which is embedded in most treaties that the defendant can't be tried for an offense that he wasn't extradited for. So if you're charged with 7 counts and you are extradited in 7 counts, you can be tried in those counts. And we had a lot of litigation about extradition. Nick and his team, to their credit, my view, ultimately dropped 6 of the original 13 counts because of extradition issues. But one count that was in dispute was about whether or not Sam could be charged with violating campaign finance laws. And the issue there was that in many countries, campaign finance violations are not crimes. And if it wasn't a crime in the Bahamas, he couldn't have been extradited for it. And we had a lot of litigation about what the warrant of surrender meant, which Nick referred to. The original indictment had 8 counts, one of which was the campaign finance count, but the warrant only listed 7 of the counts, not the campaign finance count. And we had a lot of litigation over this, in which the prosecutors, in my view, were forced to take a position where they were really guessing at what the Bahamas intended. It was not, I don't fault them at all. They were doing their job, but no one really knew. And they were in court arguing, well, this must be a clerical error. The 8th count was supposed to be on the warrant, and therefore, Judge, you should let it go forward. Until finally the Bahamas knocked on both of our doors and said, no, actually, we didn't mean to include. And the government, to its credit, did not move forward on that count. And I think had we moved at a slower pace, things like that would not have happened, where a U.S. prosecutor is forced to guess or take positions about what another country thinks its treaty means. So that's my second point. And my third point, I just want to come back to something that both Nick and Christian touched on, which is this idea of how the losses came into play. And again, this is, to me, it's a policy question. It's not really, did the government team make or not make the right decisions, the right motions, did the court rule how it should, or did we do the right thing? That's for the appellate courts now, it's not for us. But from a policy point of view, we had a very unusual situation where customers have been repaid or will be repaid 118 cents on the dollar. And it's even more unusual if you think about it, because FTX was an exchange. It wasn't an investment advisor. So you put your money on the exchange, and then you made trades as you saw fit in Bitcoin or other cryptocurrencies. And the notion that someone who put their funds on the exchange a year ago and traded in cryptocurrencies for a year would not have suffered any losses at all. None of the million users would have suffered losses. Seems to me unlikely.
Mark, yet, we actually have a question from the audience.
Yeah, sure.
It's perfectly on point for what you're talking about right now. And the question is, aren't we missing the point here? SBF misappropriated investor funds, didn't he? And if I could just build on that, maybe with an illustrative example, let's say I have a Ferrari and you take my Ferrari. It's a vintage one. In the meantime, you take it for 2 years. And in that period, I could have sold it for 4 times as much. Meanwhile, the market drops. It's worth what it was 4 years ago, except inflation. So maybe I lost a little bit. You give it back to me in the same condition. And you're like, here you go. I mean, there seems to be something worthy of punishment there, right? I mean, or is it completely not culpable?
No, look, I'm not going to speak to the sentence. I'm not going to speak to, that, again, as I mentioned at the beginning, I really can't. But what I was getting to, Gary, and I think you anticipated me, is if you were sitting as the trier of fact, if you were the judge or the jury, wouldn't you want to know that? Wouldn't you want to know that, in your example, the car was returned as before? And in our case, that didn't happen. Right. So,
or for sentencing, I might want to know to mitigate. Maybe it's a different sentence for where you set the car on fire.
I didn't handle the sentencing. Sentence I'll leave to Nick to discuss. It was discussed in the sentencing. Okay. I'll leave that to Nick. But from the jury's point of view, the trier of fact's point of view, this was the same as if every single dollar had been lost. And maybe as a policy matter, that's how we want to do things. I don't know, but it seems to me they have a different feel. And that's sort of the point I'm making here.
Yeah. That was terrific. Mark or Nick, do you have observations about Mark's comments that you might want to add?
Sure.
He agrees with everything I said. He agrees with everything I said.
I'll start with the point that Mark and Gary were discussing at the end there, which is this question of recovery through the bankruptcy. As Mark alluded to, this was something that came up. This was an argument the defense made at sentencing that Mr. Bankman-Fried should receive a lighter sentence because largely due to rises in certain cryptocurrency prices and certain investments working out that the asset pool in the bankruptcy is, or at least appears to be enough to cover certain customers' claimed value as of the time of the bankruptcy. I'll say, and this is not, the criminal team that did the prosecution here isn't directly involved in the bankruptcy, but my understanding is that many of the customers remain unhappy that, number one, they were deprived of their money for a period of years, and number two, that they don't get, and I think this was Gary's point, the value of inflation. There are, of course, also other categories of victims, investors, lenders, et cetera, that I think are not getting that same amount of recovery, although I'm not an expert on this. Let me circle back to some of Mark's earlier points. This question of regulation by enforcement comes up a lot in cryptocurrency matters, and I think it's important to distinguish the actions by the SEC and the CFTC versus a criminal prosecution by the Department of Justice. This particular case didn't resolve whether or not any of these cryptocurrencies were securities or commodities. In fact, that was not even one of the questions really that came up during the case. And that's because I think criminal prosecutions are really ex post. And so they are intended to punish conduct that violates general United States criminal laws, not something specific to regulation. So at least I would submit, and this is at least my view, that it's natural to expect that the result of a criminal prosecution will not clarify the regulatory landscape. What it should reaffirm, and what I hope it does, is that you can't steal people's money. And I think that's really the lesson of this. And I think sort of more generally as a point, when people are talking about should we be regulating cryptocurrency and how should we, in some ways, whether you believe in total deregulation or a highly regulated environment for cryptocurrency, criminal prosecution remains sort of like the safety net or the backdrop, where if you do things that fundamentally violate laws that are offensive to people's expectations about what will happen with their money, you face criminal prosecution. And that could be whether you're dealing in dollars or pesos or bitcoins or dogecoins. And I think that's at least how I think about criminal prosecution, which is it's not ex ante, it's ex post. It does have a deterrent message, but really it's about criminalizing or prosecuting bad conduct by individuals. And then the last thing I just wanted to comment on was the discussion, very interesting discussion about the Binance case. And I wasn't involved in that. I only know things that I've read. But I think, to me, the biggest distinguishing factor is the conduct at issue. Here, we had misappropriation of billions of dollars of customer money. There, I believe, CZ, the founder of Binance, pled guilty to unlicensed money transmitting, which is a very different type of conduct. And I think that is the greatest distinguishing factor between the two defendants. Of course, they're both founders of cryptocurrency companies, but I think, to kind of put this in an analogy, famously in the 1970s and 80s, United Foods, which was the largest distributor of bananas in the United States, engaged in a massive FCPA violation, foreign bribery, accounting scandal. People went to jail all around bananas. And when I was in law school, in my first year law class, we actually read a torts case or a short criminal case about a guy who stole bananas. Both cases are about bananas. They're wildly different in terms of the conduct. And so we would never equate them together. And I think that's at least my suspicion about why we have different results in these cases. Both involve cryptocurrency, both involve founders of cryptocurrency companies, conduct very different. And to me, that's the biggest indicator of why we have different sentences.
Mark, did you want to respond to anything before I throw a couple more questions?
No, I think we should leave time for questions. I see it's almost 3:20, so.
I have one question, which I think in this area is really interesting. Both in Binance and in this Bankman case, they both were outside of the U.S. jurisdiction physically, although they both have gotten in trouble because they were doing business, at least virtually, in the U.S. And a couple of interesting questions, just almost out of curiosity. Would Bankman have been prosecuted had he stayed in the Bahamas? Were they interested in prosecuting him? And did that perhaps have something to do with his willingness to come? Or do either of you have any thoughts about this issue of people doing business all over the world remotely and then breaking U.S. laws through the cyber world, for one of an expression?
Yeah, I mean, I think there's an issue that's playing out now in the civil side relating to crypto and entities like Binance about, do they actually have a central location, a headquarters, and so forth? Because in our system, you always talk about whether where does an entity have citizenship, and when you start thinking about entities like Binance, it can be tricky. So that's sort of playing itself out now. I don't know that it's come to ground. I don't know if Nick has a different view on that.
Nick, any insights?
Not really. I mean, it sounds like neither of us really know the answer about the Bahamas, but certainly I don't. I know that we, put it in a warrant and sought extradition. I don't know about anyone else's plans.
Christian, should I pop in with one of the audience questions?
Yeah,
Is
that'd
that
be
okay,
great.
Tom? So we have a question. What are the panel's thoughts on NSBA versus Yellen and the outcomes that the 11th Circuit appeal might have on FinCEN BOI reporting? I'm definitely not answering that, so not it. Anybody want to take that on?
I think, Gary, that little esoteric. Are there some other questions that we might want to focus on?
Yeah, sure. So here's a question. Will Sam Bankman-Fried's parents, who reportedly received proceeds of the fraud, will they ever be prosecuted, do you think? What's everybody's take on that?
Well, I'm not going to comment on that one, and no one should read my no comment into that. But just as a matter of policy, we don't comment on.
I'll note that Nick's left eye twitched a little when he said that. So
yeah, and I don't represent the parents, so I can't comment either.
A big question for me has been Sam Bankman-Fried was really a tremendous personality. And as both of you mentioned, there was so much media attention on this particular case. Just as a practical matter, how does that influence what goes on? Perhaps maybe you don't talk about it from the Bankman-Fried trial, but in general, when there's this much publicity, how do lawyers deal with that? And how does the court deal with that?
Yeah, I mean, my view is the rules are a little bit behind on that and need to catch up to the realities. Both Nick and I and our teams went through this. By the time of trial, there had been a million stories about FTX and SAM. And they weren't just in the Wall Street Journal or the New York Times or the FT or Bloomberg. You couldn't possibly write a million stories in those, but they were in social media, website-only media, influence, and so forth. And certainly from the defense point of view, something we did in a study of this is in one of the submissions to the court, something like 98% of those were negative. So, in a world where that's the case, can you really just follow the old traditional approach of the client shouldn't speak to the media, the lawyer shouldn't speak to the media, and you just go to try your case in the courtroom? Because in that lead up, you're going to have every possible participant is going to be exposed to the media. The attorneys will be, attorneys for potential witnesses will be, potential jurors will be exposed. And if it's overwhelmingly negative, is it enough to just say, well, we'll wait till we get our day in court? So my own view is I think that the rules need to be updated a little bit to make it clearer about what kind of fair response the defense can make when these things happen. But the current rules in Southern District of New York, which I think are similar to most around the country, is, the attorneys can make statements, and usually it's the prosecutor can make a statement on the day of the indictment. And just in the course of my career, those statements have gone from being a two-line, just to let everyone know we indicted so-and-so on X charges, to sometimes fairly elaborate presentations with PowerPoints and reviews of the anticipated evidence. And from a defense point of view, when something like that happens, if there aren't clear lanes in which you can respond, which at the moment there aren't, it really can have an impact. So I think we should think about maybe updating these to allow clearly what the defense can and can't do in response to that.
And Nick, what has been your experience in these situations? How does?
Yeah, I think what came to mind for me when the question was raised really had to do with jury selection. When you have these cases with a defendant who has a significant public profile, and as Mark said, you've got a lot of media out there, including during the trial. The jury selection becomes more difficult. I remember I think maybe the night or two before this trial started, there was a 60 Minutes piece that played, and so I think it's always an issue, and it makes jury selection go a little longer sometimes. It requires a few more prospective jurors. Obviously, ultimately, the goal is to find 12 people plus however many alternates that can be fair and impartial, notwithstanding whatever they've heard or seen or read. But yeah, it becomes more challenging in cases that have a public profile, and that's not unique to this case. I think there's several cases going on right now in courthouse across the street where that's an issue. Yeah, it's something I think certainly is worth continuing to think about, both at the trial stage and the pretrial stage.
Nick, earlier you had mentioned on this exact topic, that this trial proceeded more quickly. And I think as a tenet of justice, there's a general view that justice should be swift, yet, as Mark also noted, methodical. But without looking at the specific case, I think most people, if you poll them, would say, yeah, justice should be done with, somewhat contemporaneous to the wrong. But why specifically in this case why, and is that an injustice when we just choose one case or two cases to be super swift on, perhaps in response to popular opinion?
Yeah, well, I think when we're thinking about justice being swift, there's a few components to it. Here, they all sort of aligned to result in the case moving quickly. One is how long between sort of the beginning of the investigation and the charges, and that is largely driven by the pace of the investigation and the amount of resources devoted and people, whether someone confesses or pleads guilty or whatever early on. Then there's the pace of the case, and that's driven by the parties and also by the judge in some circumstances and their calendars. Here, Judge Kaplan had time. I mean, Mark might be able to speak to it more, but I think Mr. Bankman-Fried was interested in having a prompt trial. If he had taken a different approach, maybe we wouldn't be doing the trial yet. And then of course the other variable here is extradition. I do think though that there actually, there are other examples. Famously, Madoff was arrested, I think maybe like a week after the Ponzi scheme imploded, and there's, I think everyone maybe remembers the pictures of him walking around the street during that interim period where the press is coming up to him and he pushes it away and everything like that. And so there have been other times where I think cases have moved quickly and it's a product of confessions or evidence or whatever it is, not just public opinion. Obviously, public opinion can't really drive ultimate charging decisions because you got to prove it at the end. And so if it was exclusively, people want someone charged, then these cases will all fall apart when you got to a trial. So it's got to be supported by evidence. And that's why also we have a grand jury and everything like that.
I wish we had scheduled 2 hours. This has been a terrific discussion. One thing I would really like to thank our two panelists, because it's very unusual for to have this kind of a discussion about a case that's so recently been decided between two of the principal actors, and the actors is the wrong word for it, but the two lawyers in it, that we can have a very reasoned and interesting discussion about a really important case. And so I wanted to thank both of them for their willingness to take out time and to share their observations about what went on. And I'd like to thank the Federalist Society for allowing us, for Gary and Jack and others that have made this possible. And so we really appreciate it. So Jack, we'll turn the time back to you.
Well, thank you very much, Christian. I don't have too much more to add, but just to echo your thanks to both of our speakers, Mark and Nick, for joining us today, and to you and Gary as well for helping to put together this program and guide it today. With that, thank you all very much for joining us. We encourage you to keep an eye on our website and your emails for future events. And as always, we do welcome feedback at info@fed-soc.org. With that, thank you all very much for joining us today. We are adjourned.